So my name is Vivian Newman. I am the Deputy Director of Dejusticia. Dejusticia is a think and do tank based in Colombia, but working not only in Colombia but in the global south. We work in human rights and we also work in the rule of law. We have a methodology of work that combines research and action. What have we done lately on transparency? Basically, we want to open the intelligence archives. The culture of secrecy in our intelligence authorities is enormous. And we have an intelligence law, we have a transparency law, but these two laws collage. There's a tension between these two laws. And we need to open those archives because in the past, in the Colombian conflict, there has been communication between the security services and paramilitaries. And there have been killings, assassinations, and disappearances that are due to the fact that our intelligence services have this relationship or have had this relationship with paramilitaries, especially right-wing paramilitaries. So what we're doing is trying to open those archives. And one of the actions that we're taking is filing a lawsuit against a decree that develops the intelligence law, because this decree says that everything that is related to intelligence has to be secret. And this is against transparency. I understand, and we all understand, that a portion of intelligence services have to be secret, like the agents or the means that they're using. But not all of the information has to be kept secret. We have to divide and use a principle, the principle of maximum transparency, and decide which of this information we can access and which of this information has to be kept secret. We all know that if there's a violation of human rights, archives have to be open. But how do you know if there's been violation if you have no access to the archives? So then there's a vicious circle that we're trying to break. And I think it is important to consider the possibility of joining this lawsuit so that we understand that the principle that has to be put in place is the principle of maximum dissemination, the principle of maximum transparency. And only if some conditions are met, you can make secret or make an exception to the access to information. And if you comply with those conditions, then you can make the exception. The conditions that are considered in the transparency law are three. You have to be in a category, specific category. Security is one of the categories. You have to be part of a law, a statutory law. And the third one is that there has to be a damage. If you, in the intelligence services, cannot prove that there is a damage when you give that information, then you have to give it out, because there's more damage protecting the information than giving it out to the public. It's more democratic to give it out to the public. Bear in mind is that access to information is an instrument that serves to have more justice, more truth, and more reparation. In what sense? More justice, because if there's violation of human rights, then you have the information to go to the judges and file the lawsuit and explain your case. There is more truth because you find what are the relationships between, in this case, the paramilitaries and the intelligence services that are causing and that are part of the conflict. And there is more reparation because if the victim has been considered, for example, in our case, guerrilla members, then they're going to repair their reputation. But also we will be able to know who is responsible, and that person will be obliged to pay not only money, but to pay the respects and to pay what is required for indemnification. And then we comply with those three steps: truth, justice, and reparation.